Hello, everyone. We are ready, and we can start our session today. Welcome. For those who join for the first time, my name is Daniele Caramani. I will be chairing today, and our session today is a research seminar. You might be aware that the EGPP seminar series combines various types of seminars, book presentations, as well as the workshops by the EU Studies Working Group organized by the EU researchers, but today is a classical research seminar. And I'm very happy to welcome today's presenter, Bruno de Witte, who is Professor of European Union Law at Maastricht University, where he is also co-director of the Maastricht Center for European Law. He's also part-time professor at the European University Institute, and he was in fact a professor at the EUI, professor of EU law for many years in the past. He's currently part-time professor through his affiliation in the project Integrating Diversity in the European Union, in which he coordinates the work package on legal feasibility and constitutional acceptability of differentiated integration. His talk today will be on the adoption of EU COVID recovery plan, policy shift, legal engineering, and institutional transformation. And we are particularly happy to have him to continue also with talk on legal issues, because we should not forget that EGPP is an interdisciplinary program. So thank you very much, Bruno, for accepting our invitation and for being with us today. We are continuing to be on Zoom. Things are slowly getting back also to seminars in presence, but probably for our seminars, this will be something for the fall. In terms of format, Bruno, you will give an initial presentation, and then we go straight to Q&A. You know by now, I think, how this works. If you like to ask questions or make comments, you can use the hand function. Please keep muted while you're not speaking, but if you can have the video switched on, if that is possible. So thank you very much, everyone, for being with us today, and especially to our speaker. Bruno, please, if you like to share your screen, the floor is yours.
Yes, thank you, Daniele. I will share my screen. Can you see it?
Yes.
So thanks for inviting me to talk in the seminar series of EGPP. So what I want to do here is to present my take on the EU's COVID recovery plan. Let's say to present a synthetic account of what happened under the headings that you see here in the title. So to present it as a major policy shift in the EU's macroeconomic policy, as a case of legal engineering, so where the lawyers had to find solutions in order to reach the policy goals. And then, but with a question mark, I will discuss whether what we see here is a case of major institutional transformation of the European Union. So the question mark only refers to the last point, institutional transformation, because I think on the other two elements, policy shift and legal engineering, there's no room for doubt. We really have seen those things happening here. Now, before I deal with these three issues, I will first briefly present or recall for some of you what this plan is about, the recovery plan, and also the key political moments that have led to its adoption. So first of all, what are we talking about here? So the European Union has, of course, adopted a number of COVID-related policies in 2020 and also this year in relation to, public health coordination, free movement of persons, relaxing the rules on state aid, etc. I'm not talking about all these things here. I'm only discussing here the economic recovery plan, which was adopted and which was called by the European Commission when it was first presented, Next Generation EU. So that's the name of the recovery plan as a whole. The label is interesting because already at the time, the name was chosen so as to indicate that in the Commission's view, at least, this was not just about helping the states to deal with an emergency, but was also about preparing the future. And we will see how this comes back in the way the plan was then rolled out. The package as a whole has a number of components, and I've put on this slide the three main components, the three main instruments, if you want, that compose the package. Why this disjunction? For legal reasons. Okay, so each of these elements has a different legal basis. So there are legal grounds related to the way the treaties are structured that explain why we didn't get one single instrument, but rather three, or even a bit more than that. But the three main ones are here. First of all, the European Union Recovery Instrument, EURI, which is the overall container of the recovery plan, in which you see the mention of these 750 billion euro, which is the overall amount of money in the plan. And also the allocation happens here to the various spending programs. Now, the main one, accounting for 90% of the total sum, is the Recovery and Resilience Facility, which is the object of a separate regulation, which is much longer actually than EURI. So the RRF is the heart of the matter, if you want. It's the main spending program, which is composed half of loans for the member states and the other half of what is often called grants. So basically subsidies to member state projects that do not need to be repaid, unlike the loans. And then the third element of the package is a revision of the own resources decision, which traditionally is the instrument that describes the revenues of the European Union. Now that decision has been amended so as to explicitly allow the European Union to borrow these 750 billion on the financial markets, on the capital markets. This has been authorized by the own resources decision. If you want, what has been decided is that this debt, these loans taken by the European Union on the markets will be a new form of own resource for the European Union. Now, let me then briefly recall the key moments leading to the adoption of the package. In my view, the first important moment, political moment, happened very early on in the coronavirus emergency, already on the 25th of March, 2020, when 9 heads of government, including those of France, Italy, and Spain, wrote a letter to the President of the European Council, in which they called for a common debt instrument issued by a European institution to counter the damage caused by the pandemic. The next day, there was a meeting of the European Council, and the initial reaction of a number of countries, led by Germany, but including also the famous frugals, you know who they are, the Netherlands, Austria, Sweden, Denmark. Their reaction was, no, we don't see the need for it. We can cope with the pandemic ourselves. We don't need European support, and we certainly don't need a transfer union. We don't need a transfer from us to the poorer member states whose public finances are in disorder. That was the initial move. The European Parliament then shortly afterwards supported the idea of creating this new, what they call then recovery bonds, guaranteed by the EU budget. But the decisive moment, the major turning point, was the Franco-German document, which was published on the 18th of May, in which those two countries advocated for a mechanism whereby the European Commission would be allowed to borrow 500 billion, that's the figure they mentioned, on the markets, which would be spent as non-repayable subsidies to the member states. So not as loans, but as subsidies. So what happened here is that Germany had changed sides. It was no longer opposed to this solution. But the key, if you want, the key to the change was that what was being conceived here was no longer common debt, jointly engaged into by the member states, but European Union debt. That was the trick, if you want. The idea was, okay, let the European Union borrow the money. So it's not the German taxpayer or the Dutch taxpayer that will have to pay for this. It's the European Union that will borrow the money. That was the miracle solution that allowed Germany to change its position. And on that basis, then the European Commission 10 days later presented the whole complete policy package and detailed legal texts, which of course it had prepared already before, but the Franco-German document gave it the political green light, if you want, political backing for the policy package to be presented. And then the next moment was, as you may all recall, the famous European Council meeting of July last year, which took 90 hours, and at the end of which the European Council reached a very detailed consensus on the NGO package, but also on the EU's multi-annual financial framework for the next 7 years. Because it so happened, by coincidence actually, that the COVID emergency coincided with the year in which the EU had to adopt its new multi-annual financial framework. And that is something that has to happen. It cannot be postponed. And so the combination of the two things helped. It helped to, to focus the minds of the governments on reaching a consensus on both elements. And what we then saw in the following 6 months is a long period in which this basic political agreement of July was transformed into a series of legal texts. This required further discussions between the states. Even though there had been a sort of consensus in July, there were further discussions, and you may remember that Hungary and Poland for a long time threatened to veto the whole recovery plan because of this new instrument, which was part of the multi-annual financial framework, the so-called rule of law conditionality. So the idea that any allocation of EU funds on any of the programs would henceforth be subject to compliance by the receiving states with rule of law criteria. In the end, the veto was overcome, and so the Council confirmed the July agreement, and there was also further discussion with the Parliament, since some of the package required co-decision and trilogues between Council and Parliament. And so the overall result is that you have two budgets now. The ordinary EU budget under the MFF, which is slightly higher than in the previous 7-year period, so 1,074 billion. And then there is a separate budget for the NGO, for the recovery plan, of 750 billion, which is temporary. So it is to be spent in the next few years. And in fact, in the next few years, let's say in 2022 and 2023, NGO expenditure will actually be higher than the ordinary EU budget expenditure, just to indicate the amounts that we're talking about here. So what is the current state of play today? At this point, 18 states out of 27 have submitted their spending plans for the facility, the RRF. They were supposed to do so by the end of April, all of them, but only 18 states have managed to do so, to submit their plans, which is a precondition for receiving any of the funds. And the European Commission services are now examining those plans. What is interesting to see is that a number of countries, including Germany, France, Belgium, and also Hungary, only requested the grants, the subsidies, and did not request any loans. What is the reason for this? Well, as we know, and due to the massive purchase of government bonds by the European Central Bank, the current interest rates on government bonds are very low. And especially they're very low for countries like Germany and France or Belgium. And so if states raise loans themselves, on their own initiative, they're not going to pay anything more than if they accept the loans of the European Union. And there is no control, of course. It's not part of what the Commission is then going to monitor. So there is in fact an incentive for many countries to forego the loan part of the recovery plan. So we can already predict now that the whole sum of 750 billion will not be spent actually. Now the whole thing, the actual start of the borrowing by the EU and then of the spending of the plan is still on hold because the change in the own resources decision has to be approved by all the national parliaments. So this is a procedure which people have called a sort of quasi-treaty revision procedure. The own resources decision has to be approved by the Council unanimously, but then after this, it has still to be approved by all the national parliaments separately. And this has been slow. So there's still 5 countries missing today. 5 countries that still have not approved the own resources decision, and therefore the whole thing cannot yet enter into operation. So the expectation now is that sometime in June or maybe in July, the Commission will finally issue its first set of bonds on the markets. So we'll start raising part of the 750 billion on the markets, on the financial markets. And then shortly after that, in July or maybe in August, the Council will then adopt the first round of spending decisions. So the first allocations of money to the member states. And then sometime in the future, we still expect a judgment of the German Constitutional Court on whether the new own resources decision is compatible with the German Constitution, or whether it affects the budgetary autonomy of the German parliament. There's a court case which is pending. The Constitutional Court has already decided that Germany could ratify the own resources decision in the meantime, but something may happen in the future. There's like a sort of Damocles hanging at least above the German contribution to the system. All right, so this was by way of very lengthy introduction. Let me now come to the first point of my argument, is namely to show to what extent we've seen a policy shift here, a shift in the EU's macroeconomic policy. And I do this by presenting on this slide the main characteristics, the sort of rough description of the EU's macroeconomic policy before the corona crisis. And on the next slide, I will then emphasize the differences that we've seen since. So if we go back to early last year, before the crisis erupted, the role of the European Union was essentially one of controlling or monitoring, if you want, national fiscal policies. This was the famous European semester, in which the EU institutions develop policy recommendations addressed to the member states, in which the lodestar, if you want, the basic idea is that budgets, national budgets should be balanced. So reducing debt and reducing deficits was, as we all know, the main idea behind this. This whole system of the European semester has been, described by people as a massive paper pushing exercise. There's a lot of talk, a lot of writings, a lot of papers, but there's no effective sanctions for non-compliance. So it's not a very effective system. Alongside this, we did have European financial assistance to single countries. But this assistance was limited to situations of sovereign debt emergencies. So countries finding themselves in a sovereign debt crisis could request loans from Europe These loans were subject to strong conditionality, imposing austerity, and they have been very much criticized for that. And also, this assistance has been largely outsourced to a non-EU organization, in legal terms, the European Stability Mechanism, which was set up by the Euro area countries outside the EU structure. Alongside this, we've seen ongoing discussions for many years already on the idea of creating a permanent, so a non-emergency fiscal capacity for the Euro area. That is to say, a financial capacity for the Euro area to encourage its members to engage in structural reforms and in long-term investment. So the Germany and also the other frugal countries have always rejected a transfer union. So they've always sought to limit both the amount of such fiscal capacity and also its nature. So nothing much happened there. So that was the situation until early 2020. So if we now look again at the EU's policy in macroeconomic policy, we see a number of changes. First of all, the EU's control on national fiscal policies has been put on hold. So the rules limiting member states' borrowing on the markets, so the rules on deficits, budget deficits and debt were suspended. And they will not be reimposed until at least 2023. Instead, what we see now is that the European Union offers financial support to all its member states. So not to the ones who find themselves in an emergency crisis, but to all the member states, whereby the criteria for distributing the money of the recovery fund favor the weakest economies. So the weakest economies receive relatively more money. The support takes the form not only of loans, which was the traditional instrument of assistance, but also subsidies on an existing model, of course, which is that of the structural funds. The money is being raised by the EU through its own bonds for the first time at such a scale. What this means is that the member states do not have to raise new debt. So for the member states, for countries like Italy or for Greece, let's say, this is money for nothing, money for free. They don't have to raise new debt. The money is raised by the European Union. And still, there is no obvious, explicit interstate transfer. So it's not the German taxpayer that is paying the money that goes to Greek firms here. It's the European Union that raises the money through this new debt mechanism. In terms of the object, what we're talking about here in this plan is not just recovery from the COVID crisis, but also resilience. Note the use of both words in the labeling of the program, of the facility, the recovery and resilience facility. So the plan also serves, in fact, to promote the flagship policies of the Commission, which are the Green Deal and digital transition. So what happens here is that you have a major development of EU steering of national policies by means of funding. And this is a topic which I believe Pierre Schlosser will discuss in more detail in his presentation, in his seminar next week. So that's for the policy shift. Now, the policy shift happened through what I call legal engineering. Now, I'm not going to go into the detail of this because we have a mixed audience today. So those of you who are interested in this will find a much more elaborate discussion of this aspect in my article in Common Market Law Review. But basically what I mean by legal engineering is this, is the fact that the legal services of the three institutions, actually, Commission, Council, and Parliament, work together. So this is not a situation in which we find rivalry or opposition between the institutions or between their legal services arguing against each other. They were all arguing in the same direction, namely to find the way to make it happen, the way to make this political construction, this political project work out in practice. And in order to do so, they had to be creative, okay? They had to find creative legal solutions for some of the problems. So one of the interesting aspects of this is that the Council's lengthy opinion, the legal services opinion on the compatibility of the plan with the treaties was very quickly made public, which is unusual because most of the time, the Council especially, likes to keep its legal opinions secret, confidential. Here, this was made public very easily and very quickly, basically to disarm legal objections which were being raised, especially in the frugal countries. So in countries like the Netherlands or also Finland and Sweden and so on, people said, oh, there's lots of things here that are not possible, that are not compatible with the treaties. And the Council's legal service opinion was there to say, no, everything is all right. So there were two basic tricky issues from a legal point of view. One is the issue of competences and legal basis. As we all know, the European Union can only act to the extent that the treaties allow it to act for a certain purpose in a certain field. So the two legal bases that were used in this case were relatively obscure. Both of them had been used in the past, but not for major projects. One of them is Article 122 TFEU, which is part of the chapter on economic and monetary union that allows for financial assistance to countries facing exceptional circumstances. This had always been seen as allowing for assistance to specific countries, single countries facing exceptional circumstances. What happens here is that this legal basis is used for a program that covers all the member states. So the reasoning is here, all the member states face exceptional circumstances due to the COVID crisis. And therefore, the financial assistance can be directed to all of them. At the same time, the actual spending program was based on Article 175, which is part of the cohesion chapter of the treaty. So this is a little article which says that the European Union can take measures to promote cohesion outside the structural funds. It's a very vague article. It had been used a few times before, but for much smaller programs. This sort of quite vague little article is now being used as the basis for a spending program amounting to 750 billion euro. In other words, it is discovered as a basis for a true EU macroeconomic policy. The other tricky legal part is the public finance rules of the European Union. And especially the fact that the European Union is now taking big loans on the markets. Now, there have been precedents for smaller loans, up to 60 billion, which were then used for so-called back-to-back loans to the states. So the European Union, the Commission, went to raise money on the markets, which was then immediately provided to specific member states in the form of loans. What we get today is something very different. Now the European Union is going to raise 750 billion euros, and half of that is going to be spent not on loans, but on grants. The money will not return. So this is a major change in EU budget practice, because it used to be thought that since the EU budget must always be in balance, that is to say, it cannot show a deficit, therefore the European Union cannot raise major debt. This practice was not spelled out in the text of the treaty, and what you see here, therefore, is a change in practice more than in the actual rules. A change of practice which is, however, politically supported by the fact that the own resources decision was modified to explicitly allow this massive borrowing, which means that all the governments agree, because changes in the own resources decision have to be taken unanimously, and all their parliaments, the national parliaments, also are called to approve this change in practice. So on this question of legal engineering, what has happened is some really creative solutions have been thought out and proposed, but remaining, that is at least my point of view, remaining within the limits of what is possible and what is allowed under the current treaties. And let me then move to the final part, the part with the question mark. Have we seen here, or are we seeing, a major institutional transformation of the EU? Now, that debate also happened with the Euro crisis and the reforms that happened during the crisis. So some people have argued that the Euro crisis reforms manifested a major transformation of the EU's institutional system, whereas another school argued that what we saw was much more path dependent, that prior institutional developments were confirmed and were reinforced by the Euro crisis. I'm rather convinced by the latter interpretation. Now, what we see now is that, again, we have a sort of replay of this debate, whereby some commentators see a major institutional change or transformation of the EU due to the COVID reform plan. But there are arguments for saying that the institutional transformation is not so important at all. And the arguments that one can put here is the fact that the whole decision-making on the plan, this time at least, took place within the EU's institutional framework. So unlike what happened during the Euro crisis, we haven't seen any outsourcing of powers to new independent agencies or to international bodies like the European Stability Mechanism. Everything happened within the EU's institutional framework. It's not clear, as I will explain in more detail in a moment, it's not clear which institution sets to gain from the way in which the plan was adopted. And the European Union is not yet given a stable budgetary capacity because the recovery plan is a temporary plan. Now, let me elaborate a little bit on these points. Now, let's first look at the decision-making for the adoption of the plan. Now, that decision-making was fragmented because, as I said before, each of the elements of the plan had a different legal basis and therefore also required a different mode of decision-making. So the RRF regulation was adopted through co-decision. The URI regulation, the container program, was adopted by the Council by qualified majority vote, but without participation of the Parliament. And the own resources decision was adopted by the Council, acting unanimously, followed, as I said before, by the need for approval by each state separately. So very different decision-making rules, but since all these things were part of one political package, they were actually combined. So what we saw is a kind of mixed decision-making mechanism. Now, what emerges, what is quite clear in the way it happened, is that the Commission played an important role. The Commission confirmed its right of initiative here. All the elements of the package had been proposed by the Commission, and that institution possessed the technical expertise and also the legal drafting capacity which was needed to bring this plan to fruition. As for the European Council, it of course played a crucial role here, but one can argue that what it did is to play its normal role, what is expected of the European Council, namely to take the big decisions. If you want to preempt the role which is formally given to the Council of Ministers, when it gets tough, for the really big, difficult decisions, the ones in which unanimity is required. So the adoption of the multi-annual financial framework also previously required European Council negotiations. Well, it happened again this year, or rather last year. The new MFF had to be worked out at the famous July European Council meeting. And at the same time, the European Council also gave direction to the content of the NGU recovery plan. If we then look at the governance of the recovery fund, so what's going to happen now that the fund is being rolled out, the fund is to be entirely spent on national projects. That's interesting. So there's no EU initiated projects. It's all the member states that are going to receive the money for their projects contained in their recovery and resilience plans. The approval of those plans, which should happen in the coming months, then leads to an allocation of a first installment. And then further installments will be subject to the member states reaching the milestones and targets that are contained in their plans. The funds are earmarked. That is to say, the use of the grants and the loans is earmarked for certain purposes, at least to a major extent. So 37% of the total funds should go to green investments and 20% to digital transition investments. But what we don't see here is strong conditionality in the sense of imposing austerity measures on the states or on some states. So that has gone away, it's no longer there. What we do get now is something new, and that is the rule of law conditionality, which was opposed by Hungary and Poland and is still being challenged by them before the Court of Justice, but they're not going to win those cases. The funding decisions are being taken by the Council, which is unusual because, as we know, usually implementing decisions, policy implementation, is done by the Commission. But the treaties allow for exceptions. The treaties allow for cases in which it's the Council that takes implementing decisions. And that had already been the case with earlier financial assistance schemes. So nothing new in a way. So what we get here is a specific system of governance for the recovery fund, but not a revolutionary one. It runs on the tracks that we knew before. And so, concluding on this, if we look at the horizontal division of powers between the EU institutions, there are pointers towards stronger intergovernmentalism, but also pointers in the other direction. In the first direction, of course, towards stronger intergovernmentalism, what is the main argument here is the decisive role played by the European Council at its July meeting. There's no doubt about that this meeting was politically decisive for the success of the program. Because key elements of the package required unanimity, it had to go through the European Council. The Council of Ministers as an institution is unable to do this. But we've seen that before. Now, some people have argued that the detailed nature of the July conclusions, which go up to 60 pages, are an undue interference with the normal EU legislative process. And it's true that the fact that you had such a detailed plan, a road map in July, constrained the room of maneuver later on for both the Council and the European Parliament. So that could be an element for saying what happened here strengthened the intergovernmental institution by excellence, which is the European Council. But you could also point at elements which indicate a stronger supranationalism. The European Commission put the package together and, importantly, will oversee its implementation. And also, what happened here is that the Commission managed, through the recovery plan, to obtain massive funding for what were, anyway, its flagship policies. The policies that the Commission, von der Leyen Commission, had highlighted when it started acting before the COVID crisis, namely the Green Deal, digital transition, and so on. They now are being massively funded through the recovery plan. So it's a political success in that sense for the Commission. And in a way also for the European Parliament, even though the Parliament had only a limited impact in the decision-making and has a limited role in the governance of the fund, the actual policy shift that happened corresponds to its political preferences. And finally, that's my last slide, if we look at the vertical division of powers between the EU and the member states, Well, first of all, we haven't seen any formal competence transfers from the national to the European level, because competence transfers can only happen through treaty revision. Now, some commentators have argued that we see here a major new instance of so-called competence creep. That is to say, the institutions abusing competences which were not intended for such a purpose. I don't agree with that. I think that what we've seen here is rather the new, or if you want, creative use of existing EU competences for new purposes, which is a normal thing to do and a legitimate thing to do. The new own resources decision gives a massive boost to the EU's budgetary capacity, that's for sure. So the European Union has now a fiscal firepower which did not exist before, but it's a temporary one. So the own resources decision allows for this borrowing by the EU for the specific and exclusive purpose of funding the NGO plan. So once it's finished, once the plan is terminated, that's the end of it. So any long-term structural increase of the EU's budgetary capacity will require future decisions, which again will be subject to unanimity. In other words, the states, the member states, are still in control of the financial system, the budgetary system of the European Union. And in fact, it's the states who guarantee the repayment of the 750 billion debt that the EU is going to contract. Once the European Union will have to repay its debt, you know, that it's going to contract in starting this year, it will have to repay it from its own budget, meaning that the states who provide most of the resources of the EU budget will have to cover the repayment, unless in the meantime, they will support the creation of new own resources for the EU. And we know that there's a whole discussion going on about that, about the creation of new own resources through Europe-wide taxes and so on. We had a seminar by Miguel Maduro about this last week. On this point, there is an interinstitutional agreement connected to the adoption of the Multiannual Financial Framework, in which the Parliament managed to include a roadmap for the creation of new own resources. So there is an incentive, if you want, for the member states to think about giving new own resources for the EU, because if they don't, then they will have to repay the EU's debt in the future. So concluding on this point of institutional transformation, yes, I think there's been institutional change, interesting institutional change, but no major transformation, or at least only a potential transformation of the institutional system of the European Union. Thank you for your attention.
Thank you very much, Bruno. Thank you indeed for your very informative and interesting, very precise presentation. So we can go now straight to Q&A. If people like to ask questions or make comments, please use the hand function or write in the chat. I don't see anyone for the moment. Can I maybe then ask for one clarification, Bruno? Or if you could elaborate on one of the last things you said about the repayment. You said that this repayment will happen through the member states, unless there will be own instruments by the European Union, like raising taxes. So, assuming they will not introduce such instruments, how will this repayment happen? What will be the criteria? Which states repays how much?
Okay, so the repayment of the 750 billion of debt will be very gradual, because most of the debt will be long-term debt. So it will start slowly. So it's something that is going to happen over the next 20 or 30 years. So since the EU has contracted the debt, the European Union will have to repay its creditors. Therefore, it's the European Union budget that will have to provide for funding for the repayment of the debt. How can this happen? Since the overall amount of funding for the EU budget is limited over a 7-year period. Well, it could happen through a reduction of the spending on other policies, but that's unlikely. The European Parliament will never accept that. And otherwise, it would have to happen by an increase of the GNI contributions of the member states. So today, the main own resource, so-called own resource of the EU is actually contributions by the member states based on their gross national income. It's something like 70% of the EU budget is constituted by these contributions. And so what the own resources decision says is that the contributions of the member states can potentially be increased from, what was it? 1.4 to 2.0 of their GNI, if it's needed to facilitate, to allow for the repayment of the EU's debt. So if the EU budget in its current state is not large enough to repay the debts, then the member states will have to increase their own contributions, but based on a distribution which is the usual distribution of their contributions to the EU budget. So the richer countries pay more than the poorer countries, relatively speaking. So given this state of play, there is an objective incentive, if you want, for the member states to say, if we want to avoid that, if we want to avoid a situation in which in the future we will have to increase our contributions to the EU budget, let's instead create genuine own resources for the European Union. Let us allow the EU to raise its own money that it can then use to repay its own debts by having, new taxes on digital companies, all the things that have been discussed in recent years. So that's an interesting situation where the member states, or at least some of them, may have actually an interest in allowing the EU to construct more of a budgetary autonomy than it has today.
Thank you very much. I have Adrienne Héritier next.
Thank you very much, Bruno, for a very fascinating talk. I have 3 short questions. The first question regarding legal engineering, when you said the strategy used by the services, legal services, all the 3 big institutions, was for the lead council legal service to come forward and say it's no problem at all, from the treaty kind of how it fits into what the treaties let you do. Why would that be successful? I mean, you can move fast and say, no, it's no problem at all, and others could still protest. Mm-hmm. My second question is, when you talk about the institutional transformation and say it's a creative interpretation of existing rules, but it's not a competence creep. But so where's the line that you draw, that interpretation of a vague rule is a competence creep or not? Which are your criteria? And the third question is, you said there is no conditionality. But if you look at the structural reforms which are requested from those states who want to use loans and subsidies, these are very, very strong conditionality. Look at Italy. Fiscal reform, bureaucratic reform, judiciary reform. This is a tall order. So why do you say there is no conditionality? Thanks.
Thanks,
Adrienne. Yes.
Yeah.
Okay.
Go ahead. Okay. So on the first point, on the legal engineering, okay, the first legal service to move was that of the Commission, because the Commission had to present the plans and it had to justify why these things could be done in the way they were presented, using the legal basis that they used. So there was a first justification there. But then it was indeed, I think, the Council's legal service opinion that had a crucial importance. And why is that? Because, of course, traditionally, the legal service of the Council is there to protect the interests of the member states. They are the ones who have to defend, if you want, the member states against encroachments which the Commission or the European Parliament would like to make on their powers. So the Council's legal service is traditionally authoritative among the member state governments. They listen to what the Council legal service has to say, because very often legal service of the Council would say, no, this plan of the Commission cannot go ahead because the treaties don't allow for it. So this time the Council legal service, in a very detailed document, went through all the, the difficult points, and each time said, no, this can be done, no, this is possible, actually. The treaties do allow for this. And so this was an important argument to convince the reluctant countries, to say, well, at least from a legal point of view, we probably should accept that this can be done. And so that's why I think that the actual publication of the Council's legal services opinion was strategic. It was deliberate. It was leaked. It was not leaked. It was published without any difficulty, because it was a strategic element of the discussion of saying, from the legal point of view, you may think this is a bit dodgy, but it is not. It is actually allowed. On the second point of the competence creep, what are my criteria for finding a competence creep situation? That's a difficult one, Adrienne. I think one element here, one factor, is whether or not the member states agree with the stretching, if you want, of EU competences. Whether it's being done by one of the supranational institutions, whether it's the court or the Commission that pushes for a stretching of competences is one thing. But when it's the member states who actually agree with it, as they did here, they all agreed unanimously with this new interpretation of EU competences, then it's difficult to call this competence creep, or to consider that this is illegitimate. The member states who are being protected by this principle of conferral, the principle of limited competences, they agree that this can be done, and therefore I don't see this as a competence creep. I think this is an important factor, but there may be other elements. And then on conditionality, yes, you're right, I was too quick. There is conditionality in the program, in the recovery plan, but it's quite general, you don't see the detailed conditionality that we saw when Greece or Portugal or Ireland received financial assistance during the Euro crisis, when the memoranda of understanding went into great detail in saying, you have to do this, that, and the other thing. What the regulation now says on the recovery plan is that the member states should take into account the policy recommendations given to them through the European semester. So it's trying to impose compliance with the European semester, but in a very weak wording. So it was clear, I think, that nobody's recovery plan would be refused by the Commission. That was simply not a possibility. So every member state would get its plan approved. What the Commission tried during the sort of informal discussions is to try to plug in their semester policy recommendations. And so what we saw in Italy, which is the example you gave, is indeed a plan which proposes major structural reforms and also institutional reforms in the country. But it's basically the choice of the Italian government, who uses the recommendations of the European semester to get through reforms at the right time. This is the right time, because in order to benefit from these billions of grants and loans, Italy or the Italian government says, well, we have to do certain things. So now is the time to do them. So I see this more, I don't see this as strong conditionality. I see this more as the governments, pushing their own autonomous reform programs, pushing them through on the occasion of receiving this major financial support from the European Union. I think that's at least how I understand what happened in Italy, but maybe also in other countries. Thanks.
Thank you, Bruno. Quick rejoinder by Adrienne.
I agree with everything you said, Bruno. Just one point, I have the impression here in Italy that if this plan of reforms, which has to be kind of put on the way, doesn't come forward with results, concrete legislation in the next 3 months, there is actually either no payment at all, or if it should be paid, a repayment in case that then they don't deliver the reforms. And that would be, I mean, a huge problem, of course, for Italy.
Okay, thank you. So we can move on. Calypso Nicolaidis.
Thank you, Daniele, and thanks, Bruno, for great presentation as always. And I just want to actually follow directly from the conversation with Adrienne, but kind of enlarge it, because I had a bit of a moment of cognitive dissonance when you ended your presentation saying, oh, and having heard me, now I'm telling you this is only potential transformation. And then I was trying to think about, what do we mean by potential transformation? Because we so almost philosophically, because transformation, of course, is a process. And of course, in philosophy of science, we know that paradigm shifts happen way before there is a new dominant paradigm. So then, what is potential? And then I wanted to comment on 3. I was thinking from your presentation, what looked to me like candidates for actual transformation, if we understand it as a process. And one is the conversation just now with, so first the vertical dimension, Adrienne's question. I would argue from your response on both on competence creep and conditionality that above all, to me, it's this very autonomy and kind of bottom-up ownership that is itself transformative. That is transformative from the Euro crisis practice. So that would be the first thing. And in fact, it explains the bargain with the member states. We let the Commission do this big thing, but it is bottom-up. So as I would call it transformative. Secondly, on the horizontal between institutions, I think when there has been transformative moments in the EU history, it's exactly when progress managed to mean an increase of power, or not necessarily competence, but by every institution. It's always that kind of very subtle balancing. If you have one institution that wins over another, my hypothesis or argument is that in fact there can't be transformation because it's a disequilibrium. So it's about just finding a new institutional equilibrium horizontally as a precondition for transformation. But then I thought, well, what Bruno really means is the temporal. You said it yourself, this is of a transformative nature. Maybe your argument is only until this will become embedded in a permanent approach will this really be transformative. But then on the other hand, you've yourself just illustrated the dynamic that has been created on repayment, that there will be vested incentives to make this an EU own resources. But also, and that's back to the vertical, but on the kind of the mode of spending, the idea that you have criteria, but then they're bottom up. And there I would just, one footnote, pour transformer l'essai, to me, what I argued in one of our sessions at the Schuman Center with Philippe Van Parish was that where it will really be transformative is if we accompany this with a real ownership by cities, regions, civil society, across the EU. And that would make it, and I think the potential is there too. So yeah, sorry, a very broad question, but I mean, and last footnote, I would say that there's the footnote to the whole question is what is at stake with calling this moment transformative versus incremental reform? Maybe member states have an interest and you don't want to scare anyone. So you want to call this incremental. Yes, there's a potential, but it's in the long term. So there's a kind of second degree question also there.
Thank you, Calypso. Bruno?
Yes, no, in fact, I totally agree with you, Calypso, with all the things you said. And especially what I want to highlight is something I didn't touch upon at all in my presentation, is how this rolling out, the implementation of the plan is going to happen. And as you said here, I mean, the challenge, one of the challenges is to organize the participation of society in making the choices and in making the things happen. And of course, the regulation says nothing about that, you know, or almost nothing. So this is a challenge which is still before us. And the other challenge is obviously the capacity of the member states to use the money. As we know from the structural funds, some countries already struggle a lot to present and implement enough valid projects to use the money allocated to them through the structural funds. Now they get so much more extra money, much more than what they got under the structural funds for a couple of years. So will they be able to not just put the projects on paper, which they're doing now in these plans, but actually implement these interesting or less interesting project of green transition, digital transition, administrative reform, etc. Will it all happen? That is, of course, the big tests. And so the question whether this temporary change in the system will develop into a permanent change depends a lot on that, I think. It will depend a lot on the perception that the member states, and especially the richer member states, the perception that they get of whether this money is going to be used well in the common interest of all the European Union. If that happens, then there's chances that the temporary increase of fiscal capacity will become a permanent one. But if the recovery plan is not a success from that point of view in the implementation, then it may well be that this is the end of it, you know, and that it's not going to be repeated in the future. So this is just to link two of your comments together. It's the issue of the governance and actually implementation of the plan hangs together with the long-term institutional future. Thanks a lot.
Calypso, would you like to add something?
No, absolutely. Thank you.
Okay, very good. Next, we have Wilhelm Lehmann.
Yes, thank you, Daniele. I'm Wilhelm Lehmann. I'm visiting fellow at the Robert Schuman Center. I would like to first thank Bruno, of course, for the great presentation, and then make a short comment and ask a short question. The comment also refers to what Bruno just called perceptions of the recovery fund. And I think it's quite amusing to see, although, as Bruno mentioned, we have precedents, much smaller precedents in the past of the European Union, the public framing in many countries, particularly in Germany, I suppose, but not only, the public framing was that this was a first in the history of the European Union. It was often presented like that. And up to the point that some authors and some MEPs like Daniel Kaspari wrote newspaper articles indicating that there have been precedents to the recovery fund. Of course, this scares a lot people who are conservatively inclined, and indeed we will see the effect of these public framing efforts at the moment when the question arises whether it will become a permanent instrument or not. My question would be, the European Parliament succeeded in the negotiations on the middle-term financial framework to introduce some language concerning 4 European taxes, non-recyclable plastic, emission quota tax, etc. And I was just wondering whether anything like that, any of this is reflected in one of the three legal instruments that you presented in your talk. Thank you.
Yes, thank you, Wilhelm. I think the commitment to start discussing the creation of new European taxes is only mentioned in the interinstitutional agreement, which the Parliament, Council and Commission concluded in December, at the same time as they agreed the multi-annual financial framework. So this is a tradition, as you know, that whenever there's a new MFF, there's also a new interinstitutional agreement on how the institutions agree to implement the new framework. And it's in that document that you find this roadmap language. Now, interinstitutional agreements can be binding, depending on their language. So it depends a little bit, but this is, I think, an example of an interinstitutional agreement which can be considered to be binding. That is to say that the institutions have committed themselves to, to seriously engage in discussing those introduction of the new taxes, meaning that the Commission, I think, has a legal obligation to come forward with proposals, that the European Parliament, of course, is interested in discussing them, introducing them, and that the Council at least should start discussing them. But then, of course, the difficulty at the Council level is that any of these new initiatives would require unanimity among the member states, and that's going to be difficult. So there's a commitment to discuss new taxes, but there is, of course, no binding commitment that they will be created. It's impossible to do that through an interinstitutional agreement. But that's the document in which this commitment is being taken.
Thank you. Now we have next questions by Valentin, Alfredo, and Thomas. I'll go in this order, and I see a question also from S. Stepanovic. I'm not sure whether he or she, I don't see the image, would like to ask a question. Please let me know. But we go to Valentin next.
Thank you, Daniele. Valentin Kradinger. I'm a researcher at the Swedish Institute for European Policy Studies. I would like to thank for the presentation and a little bit go on the institutional transformation again, because I was wondering to what extent is it institutional transformation that we now have a new European treasury, in fact, by the fact that the Commission was empowered and the ESM has, to a certain extent, been sidelined in the economic governance architecture. And I think related to this, well, the ESM obviously still exists, but I mean, the European Commission will also become a key player on the financial markets. And related to this is the relationship between the EU and the member states in the process that is now starting with respect to the recovery plans. And there, I think there is not much national ownership at the moment. So I was wondering from the legal texts, how can this be perceived? I mean, we heard that there is very little national ownership, but I think the shift at the national level and the limited involvement of national parliaments is something that is worrying in terms of creating that national ownership and actually having a process whereby budgetary power is not shifted at the national level. And in the end, my impression is, but I mean, it can be interpreted otherwise, that in the stages of agreeing and approving the plans, the Commission is very much in the driving seat and agreeing and assessing member states' progress towards meeting their objectives. But, and here that's to conclude, I think it is very much still to be seen if it actually uses that powers. And I think the question I was also wondering about is the power it has now in these legal texts. Is it stronger compared to what we know from the European semester? So from that, is there any evidence that the Commission could be more active, and then thereby institutional transformation could take place? Thank you.
Thank you.
Yes, thanks, Valentin. On the first point allows me to mention something I didn't mention at all in my presentation, and that is the consequences of what happened for the differentiation in the European Union, which, as Daniele said, is actually the justification for my presence at the EUI, this project we have on differentiated integration. Now that's interesting, because what we have here is an EU-wide plan. You know, all the member states are on board here. They've all participated in the decision making, and they all benefit from the program. So it's a counter move. It's a counter move against the trend that many people saw towards stronger differentiation between groups of states. And that is, I think, one of the interesting institutional changes through this project, because before that, the whole discussion on fiscal capacity tended to focus on the euro area. You know, there was this idea that the euro area, not the EU, but the euro area should have increased fiscal capacity to deal with structural reforms in those countries. And of course, the funding that would have to be used for that would have to come to a large extent from the member states themselves. So again, intergovernmental constructions, whether ESM or not. Now, this is now abandoned. I mean, maybe we'll get back to that later on, but for the time being, the game is EU-wide policies. So no euro area specific policies of economic reform at all for the time being. The ESM, as you said, is sidelined. We know that the ESM had developed this new pandemic loan program. So it had developed this new program, making it more easier for countries to raise loans with the ESM without much conditionality. This was a nice offer, and nobody took it. So not a single member state has taken up the offer for ESM loans. Why? Because the loans are available elsewhere. First of all, in the recovery plan, but also simply on the financial markets where the interest rates are very low. So the ESM is, for the time being, looking for a role. Basically. And that's, of course, the tragic thing with the ESM. It is an existing international organization. There's hundreds of people working for it. It has to find a role to play. It's not obvious at this point of time what kind of role it will be able to play in the coming years. But that's another story. On your second point, on whether the Commission will be able to exercise, strong control on what the member states are doing. I think the time is over for that. So the impact the European Commission has had was during the talks, when the member states were still preparing their recovery plans. There was a constant interaction with the Commission services in which the Commission tried to steer them towards certain goals and certain projects. Now that the plans are being submitted, I don't imagine the Commission saying, in any case, in any of these 27 cases, your plan is rotten. You're not going to get the money. It's not going to happen. So the room of maneuver for the Commission to influence the national plans is over, in my view. It's not going to happen now. The Commission is going to approve all of these plans, and the Council is going to approve them and is going to allocate the money. I can't imagine anything otherwise. So we will have to see later on, when people are going to look at these national plans in detail, to what extent the Commission has been able to steer them towards certain directions. I'm a little bit skeptical here. My take on this, but that was also already my interpretation of what happened in the European semester, is that many of the policy recommendations and many of the reforms actually originate from the member states themselves, or from certain circles, certain political circles within the member states, who use, the European semester, or who use now the preparation of the recovery plan to invoke Europe as an argument to push through certain reforms which would otherwise be very difficult to implement. So I'm not so sure whether we see here a major policy impact of the European Commission, but rather more this interesting in-between thing. And of course, what happens as a result is what you rightly mentioned, is that national parliaments have not played much of a role here. You know, this has been very much a technocratic exercise. Also because the states didn't have much time, you know, they had only a few months to prepare these huge recovery plans, you know, which amount to hundreds, thousands of pages for each country. And so this is not the kind of thing that parliaments are good at, of course, in checking these detailed projects. So again, one would have to see later on when people are going to study this, in which countries the national parliaments may have played a role in developing the plans and in which countries they didn't. But my prediction is that in most cases, national parliaments will not have had a major impact. And so, yeah, this reinforces the technocratic management of economic policies.
Okay, thank you. Alfredo De Feo.
Yeah, thank you, Bruno, for your very clear presentation. And I think the question that is in the back of our mind is how this new architecture and mechanism that are an important shift in European policy can be on the table of the Future of Europe conference. And maybe I'm a little bit less optimistic than you, because I see a number of ambushes in the process, in the implementation. First, the multiplicity of objectives that we have, the percentage of respecting one or the other element, the strict timeline that will be attached to individual projects, and of course the generalized conditionality that is put in the regulation in the respect of the principle of the semester. If we put with this what you just mentioned, maybe a revamp of the role of the national parliaments that were not much involved in the preparation, but would be probably more involved in the implementation, and even the skepticism of some member states, and Wilhelm mentioned already this. This could raise, with this new role of the council, could raise a number of veto and blockage to the machine. So, and this is something that I don't know if what you think, if it's something that can happen, because the timeline is very short and everything should be adopted very quickly. And as you have correctly mentioned, the precedence in the implementation of European Public Fund is not very, let's say, safe for a number of those countries. Thank you.
Yes, thank you, Alfredo. I hadn't made the connection between this recovery plan and the conference on the future of Europe, and I guess there is a problem of the timelines don't work well together, because the conference on the future of the Union is supposed to do its work in 1 year from now, and that is precisely the time when the recovery plan is going to be rolled out. So I think that the member states, but also the institutions, for the time being, are happy with, you know, implementing the recovery plan as it is now, of trying to get through these reforms at the national level, to get through the Green Deal and digital transition projects. And there's not much energy left for thinking about, you know, long-term institutional change connected to the experience of the recovery plan. For that, we need more time. I think we will need more time to see how this plan works out, whether it is successful in achieving its goals, and then people and actors, political actors, might start to say, okay, what can we now conclude? How are we going to move forward? I think the conference on the future of the Union is too early for that. And I don't see much happening, but maybe I'm wrong.
Thank you, Bruno. And next, Thomas Boykers.
Yes, thank you very much. Thomas Beukers, I work for the Dutch Ministry of Foreign Affairs. Thank you very much, Bruno, and very good to see you. There were two things in your presentation, very small details that struck me. One was your comment, if I understood you well, at a certain point, when you said that the ratification of the own resource decision has been slow. And I can think of many reasons why an interest is, sorry. Yes, I can think of many reasons and interest why a faster approval by 27 member states would have been desirable. But I think if you look at it, if you will look at it from a historical perspective, there is still a chance that at the end of this month, all 27 member states will have finished their approval process. And so it will have taken only 5 months for the whole own resource decision to have been approved. I think historically that will be, can be seen as extremely fast, actually. And the other thing that struck me is the way that you started presenting the borrowing decision as money for nothing and money for free, not something of relevance to the German taxpayer, but only to the EU. I think the following discussion also in the Q&A about the way that this will in the end have to be refinanced, the guarantees that are being given by member states, and the fact that the default will be GNI contribution by member states shows, I think, that your picture is actually more nuanced, so your own picture. So I was very happy with that. My main comment and question is on the legal engineering and the consequences that follow from that for the institutional balance that you also analyze. I have in fact seen a lot of cooperation between the legal services on this project, but what I think is also interesting to see, if you look very closely, is that there are differences of approach between the legal services on how to read this this new construct legally. And one of the interesting things, for example, for me, is that if you, of course, the Commission Legal Service has not produced an opinion and does not produce opinions like the Council Legal Service, but the Commission has also published Q&As in which you can see, for example, that what the Commission argues, the Commission Legal Service argues, is that what is happening here deviates from the treaty rules, but that deviation from treaty rules is possible if you use Article 122. And then if you compare that with what the Council Legal Service says, is that what is happening here is no deviation from treaty rules, but is everything fits within the treaty rules. So I think that's already interesting to see the difference in approach and what this maybe tells us about the tensions that are there. Because even if I think and you will not be surprised that I say this, the legal construct can be defended as being compatible with the EU legal treaties, there are nonetheless tensions that I think you can identify. And I think one of the interesting tensions relates also to a comment that you made about why everybody always thought that borrowing was not possible because budgets have to be in balance on the basis of the treaty. And the way that this has been approached is that we still have, also with the own resource decision with NGU, we still have a balance that is a budget that is in balance. So, and the reason why that is so is that what has been decided is to put the whole amount of money that is being borrowed outside of the budget and the budget procedure. And I think this is an interesting approach. And obviously, considering that we have such a tremendous amount of money being added to the budget, but being put outside the budget, and now I come to my question, technically, formally means that this is also being put outside of the prerogative of the powers of the budgetary authority. So I was wondering whether you think that is relevant in your very interesting and I think convincing analysis of what this whole project means for the institutional balance, whether the fact that so much money is being put outside of the purview of the budgetary authority is relevant from this perspective of institutional balance. Thank you.
Thank you, Thomas. Bruno?
Yes, Thomas, yes, I think it is relevant. I mean, this whole idea of having a shadow budget, if you want, a separate NGO budget, which is not part of the regular annual EU budget, is, I think, the most dodgy part of the scheme from a legal point of view, because it's like a trick. It sounds a little bit like a trick. So we need to have a balance in the EU budget, but we also want to have 750 billion of debt. How are we going to do it? Oh, we will put the 750 billion somewhere else. That's how it looks like. So you need a little bit of reasoning to justify this. I think this is the most tricky part of the whole arrangement from a legal perspective. And it does have institutional consequences, because it means that the European Parliament, as budgetary authority, will decide on the regular EU budget, but will not decide on the allocation of NGO money. There's a slight compensation for that in the sense that the Parliament will get what is called a recovery and resilience dialogue with the Commission, which has already started, I think. So there will be regular discussions in the European Parliament on how the recovery plan is being implemented. But that's not the same thing as formal budgetary authority. Now, how much of an infringement of the institutional balance is this? Not so sure, because in fact, the whole spending of the recovery plan is being decided now. It's being decided by the national recovery and resilience plans. That's where the spending is actually predetermined. And all the allocations, all the decisions to allocate the money that are going to be taken in the coming years will be based on that. So there's not much room for political maneuver at the European level anymore. And there would be not much room for maneuver for the European Parliament if it could exercise its normal budgetary powers also in relation to the recovery plan. So I think that the way the institutional balance is being affected here may sound like a major way, may look like a major way at first, but in reality, in political reality, it's not so much of a big deal, I would say. And thanks for your comments on the other points.
Okay, thank you very much. I see there might be a last question in the chat. Recovery plan. How is possible to control implementation in some countries? Bruno, I read it to you. It concerns the RRF and how it would be possible to control the implementation in some countries.
Well, yeah. So I think that there is two basic mechanisms of control. One is the fact that the money is not going to be allocated, all of it will not be allocated immediately to the member states. So what they will get at first this year, so this summer, is 13% of the total amount that is allocated to the country. So further allocations of grants or loans will be subject to reaching what is called milestones and targets. So there's very detailed rules in the regulation on the RRF, what that means. So the states will have to show that what they promised to do in the first stage, they have actually managed to do. And if so, they will then get the further installments. We know this from existing EU funding programs. That's quite common. Most of the time, nothing happens, okay? Most of the time, it all goes very smoothly. So I don't expect major upheavals there. The other control mechanism, which is a new one, is this famous rule of law conditionality, which has been adopted in December of last year, whereby all the EU funds, so not just the recovery funds, but all EU funds are now subject to compliance by the receiving countries with rule of law standards. And this is, of course, the thing which Hungary and Poland especially hate a lot. Now, there things might happen, there things might happen is that at some stage, the Commission, and then if it gets the backing of the Council by qualified majority, might say to country A or B, you know, we have evidence that the money you got from the recovery plan or from some other fund has been misspent, has been used for corruption purposes or other fraudulent purposes, you're not going to get the next installment. So that's interesting. That will be interesting to see whether this rule of law conditionality system will get teeth, whether it will actually operate to constrain the freedom which the member states basically have in spending EU money.
Okay, thank you very much, Bruno. Adrienne, did you raise your hand again for a quick
Yes, just
comment?
can I just go back quickly to the dialogue, which you mentioned as an institutional compensation for the European Parliament as regards this big shadow budget now, in which the Parliament doesn't have a role. And from austerity at the role of the European Parliament, the Parliament was very happy that this dialogue was introduced, but it was not really, it doesn't really give it a say on the decisions. It's just being informed by the other institutions. I mean, in interviews, you have seen that the Parliament thinks it's a big achievement, but the other institutions, the Council and the Commission say, oh, no, we just inform them of what we have decided. So one shouldn't overestimate this institutional compensation in the form of this political dialogue or policy dialogue.
Thank you, Adrienne. Bruno, quickly.
Yeah, I agree. Yeah.
Okay, that was very quick. Excellent. So thank you very much. It is now past 2 p.m. The seminar comes to an end. Thank you very, very much indeed, Bruno, for a very stimulating and engaging session. I think it was a particularly important session and clarified a lot of points and raised a very interesting and lively discussion. Thank you everyone also for attending and for making this lively discussion possible. We reconvene in 1 week, not in 2. It's next week is the next research seminar, and it will be on Europe's new fiscal union. It follows up nicely from today's discussion, and our speaker will be Pierre Schlosser from the School of Banking and Finance. And again, I think it's important to stress that we will continue to work and discuss in a multidisciplinary way. So I very much look forward to the next session and hopefully see many of you again for another interesting session. Have a good rest of the week. Have a good rest of the day, and see you soon again. Thank you very much. Bye-bye.